Well, typically during the holidays, the police are going to be out in greater numbers, especially during the times that are more higher risk, where people are drinking, weekends, after midnight, things like that, where officers are going to be in places where officers call, watering holes or honey holes, where they know where a lot of people are going to be driving, leaving bars, and they stop a lot lot of cars. Sometimes they just follow people out of parking lots.
Yeah.
I mean, that's the simple, almost ridiculous answer is, don't drink and drive.
Yeah.
Or don't drive at all, because sometimes, people get arrested and get charged with DWI if they haven't been drinking. If they're found to have some kind of prescription medication in their purse or in their vehicle, and they don't do well in the field sobriety test, they can still find themselves going to jail for a DWI when they haven't had a drop. So, drinking and driving isn't necessarily the elements they need. Well, as we normally and often argue, in court, officers are looking for anything that's not perfect. Anything the person does that might indicate that they don't have perfect command, of their balance, of remembering, all the details about, sometimes they ask their social security numbers, things like that, people who are under stress, people who are nervous, people who may be tired, someone who stopped at 2 in the morning that might work that day, been up since 4 a.m. There's lots of things that could cause someone to not have what we think of as perfect mental or physical faculties, but, officers at certain times of night are going to make some assumptions when they see people make simple mistakes. Some officers may go through the extra trouble of asking some simple questions like, do you have epilepsy? Do you have diabetes? But typically those questions are only used to try to diffuse possible defenses later. They're not truly and genuinely trying to inquire, if that person has an issue. They're just trying to
get the case ready,
insulate their arrest from defenses.
So if an officer,
if they simply have the smell of alcohol or the admission of drinking, or they've watched you leave a bar, few officers are going to let somebody just drive away if they've shown any really imperfections in the way they've responded to the officer or behaved on the traffic stop. I think Galveston County is a little more resistant to judges feeling comfortable signing warrants 24/7 on every simple first-time DWI case, authorizing officers to go out and have people stuck with needles. At least I know that was the last time I read about Galveston County. I'm not sure if Brazoria County was doing it in every case either, but I do believe Montgomery County and Fort Bend County are probably pretty close to Harris County's policies. I think that the most common appearance that we see with people who are arrested is someone where their appearance is an area of gray area. It's an area that can be argued either way. We're dealing with people, like I mentioned earlier, who may be tired, could be, like any of us suffering from different kind of physical conditions that may cause us to not appear to be the perfectly balanced, perfectly gathered mentally person. Of course, when people do consume alcohol and it's enough to affect their brain, then even that situation goes down from there. But I'd say more people look, it's arguable one way or another, than people who are just hands down, just clearly trashed.
Okay.
I haven't seen signs of as much abuse of that as was going on probably 5, 6, 7 years ago. But I've been in situations where I was at a hearing one time where I heard an officer talking to another officer in a waiting room, and the officer was bragging that he had towed 4 Aston Martins in 1 week. I mean, time is money, even for the task force officers. They don't want to spend 2 hours of their night on 5-minute traffic stops where they're stopping somebody who's clearly not drinking and having to say, okay, sorry, check their license and get back on their way. They'd rather every stop to be something that's likely to turn into an arrest. That's the best use of their time. So certainly if an officer is driving down the road and they see a car that's speeding and they see a car that drives 6 inches over the line, they're going to stop the car that goes 6 inches over the line, even though they could legally stop either car. And either car could involve somebody who had been drinking, but the one that's showing something that's more arguable as a potential sign of intoxication, of course, is going to be the better bet for them. The National Highway Traffic Safety Administration created basically a company to produce research statistics, and called the Southern California Research Institute back in the 70s. They started conducting some experiments. They were very secretive about the actual data. They were very selective about what kind of data they put into the literature that are circulated to police officers. Some of those conclusions, some of that data is actually completely false. They continued doing some more experiments using actual arrest data in the 90s. In fact, the National Highway Traffic Safety Administration, in just the manual it released last year, started quoting some statistics that they claim they produced in a study that was done 15 years ago. So that's how far behind what officers are presented with. But None of these studies that the government uses have ever been subjected to what's called scientific peer review, where other scientists who don't have, a vested interest in the outcome of the numbers look at the research methodology and, give an okay and say, yeah, this is scientifically sound. The government has never subjected their research to that kind of scrutiny, and it shows in the numbers that police officers are given to come to court and parrot when they really haven't even read the true studies.
Now, Tyler called them roadside gymnastics. I've heard them called a number of other things. But what are the field sobriety tests? What are they? What do they entail? What they require a person to do?
Well, if you ask a police officer that, that's usually one of the first questions a prosecutor would ask an officer in trial. And the first thing the officer is going to say is, well, these are divided attention tests. In theory, with the field sobriety test, at least the ones that involve physical faculties, the walk in the line, the stand on one foot, those tests give a series of instructions to a person, and the officer assesses how well that person is both performing the physical tasks of doing what was asked of them, as well as how well they retain the instructions. So it's by dividing attention, the way they're balancing and moving, as well as the way they're remembering what they were told. And in defense of that position, I think the way they look at it is, well, if people, supposedly failed the test at a certain level when it was .01, and now that the limit's .08, if people are showing those same signs, then they must obviously be over .08 because they failed the test at the .01 or .10 criterion. So that can be rationalized, but it's not what the research actually says. The studies were done very differently from the 70s to the 90s, and it's very misleading the way the information is presented in court oftentimes.
It's rather stale.
Well, yeah, the word pass kind of creates a loaded question because the officer decides what pass is. Now, there are some objective criteria that the officer is supposed to use, and when everything's on video, that helps us a lot. Because when there's no video, the officer can say pretty much what they want. But whenever there is everything on video, sometimes we have legitimate questions of whether a person did in fact show one of the signs on the test that officers, say are part of their decision to decide the person failed when they really didn't even show that proper sign. Officers are trained that there are 8 what they call validated things that a person can do when they perform that test, and then if they don't do them according to those criteria, the officer is supposed to consider that a sign of intoxication, or what they call a clue. There's 8 of them that on the walking test. Do you want me to go through them?
Yes, please.
Okay.
Please.
The first thing the officer does is put this person into a position that challenges their balance, an unnatural position where they put their left foot on the line, and they put their right foot touching the heel of that left foot to the toe of the right foot on that line. It's designed to cause imbalance.
It's designed from the start to cause imbalance. So you start the test off already at a huge disadvantage.
Yes, and you can't use your arms. The officer is supposed to instruct the person to put their arms down at their side. Then the officer tells them, don't move, hold that position, stand just like that until I finish giving the rest of the instructions. Then, depending on which officer you're dealing with, the officer can take as long as they choose to give the instructions in the test, to require the person to stand in this position. If an officer is slow talking or very repetitive, the person can end up having to stand there for a couple of minutes. Whereas if the officer gives the instructions exactly like they're trained to do it, they should only have to stand there for about 35, 45 seconds, before they should then begin walking. So there's a lot of subjective influence that an officer, the way they conduct the instructions, can affect the person's performance. Well, from a very technical perspective, the officers are told that if the person has to move their feet in any way to catch their balance, or if they move their feet just randomly, they consider that a sign or part of the criteria to fail the person.
Right. Wow.
Often officers will consider swaying in that position as a sign, even though that's not one of the validated signs they're trained to count against the person. There's no implied consent law with regard to field sobriety tests. There's no requirement that someone participate in them. The reality is, if an officer requests a test and a person exercises their absolute right not to do them, they're most likely going to get arrested anyway. Although, the state would have much less evidence to try to pursue a prosecution with, the officer would have less evidence to try to obtain a search warrant with. Refusing the field sobriety test is probably not going to get someone sent on their way. But there is no law in any way in Texas law, and actually, there's an absolute right to decline to participate in the standardized field sobriety test under Texas law.
Could somebody record it?
Different situations have different angles that they're going to try to prove intoxication. So like you asked about earlier, there are certain those situations where a person's medical records, prior injuries, problems with their knees, their neck, their back, could be issues that could be of value to the defense. And of course, the client's job would be to cooperate with us, to go and acquire those records and bring them to us and let us review them and see if they would be legally helpful, things like that. Asking the client questions about where they were, and sometimes there's video cameras or other kind of evidence that could show if the person was drinking or how much they were drinking that the police officer didn't acquire. Receipts, credit card receipts, different things like that doing a thorough investigation, and I think most good lawyers do, to see just what there is that's available that helps, what's out there that could possibly hurt that we need to be concerned about.
Now, Jim, you actually used intoxication as a defense in a case, and I think we have some video of that as well, but can you share with us how you actually used intoxication as a defense?
Well, it's pretty rare for Texas law to allow intoxication as a defense, but under certain limited circumstances, someone who's involuntarily intoxicated, it could be a defense to certain other criminal charges, not typically to a DWI case, so that's pretty difficult. And there have been some cases that have addressed that, and it's pretty hard to make that argument that someone is driving while intoxicated completely involuntarily. The case that you're asking about is a case where it was a very unique case where a gentleman had with no knowledge, had consumed a drink that had GHB in it. And he later found himself in a situation where he wasn't aware of what he was doing, and he was involved in a pursuit with the police that lasted for 20 minutes, running red lights, there were probably 15 patrol cars involved, a DPS helicopter, a dog chase, and it resulted in a charge of aggravated assault on a police officer and felony evading arrest.
And you were able to use involuntary intoxication by virtue of the GHB in the drink as a means to get him acquitted.
The client came to me and just with total sincerity told me when he saw that video, he had never seen that before. He did not realize that had happened, although he was the only one in the truck. We consulted a toxicologist that was able to, we got a hair follicle test that showed that he did in fact have GHB in his system. We used the hospital records. Because of the pursuit situation, the sheriff department had sent an attack dog after him. He ran into some woods, and the attack dog tore him up pretty bad. And so we had hospital records to show that he had some symptoms of central nervous system depression, which would show that the drug was active in his system at the time. And just turned out that the physical evidence lined up with his explanation, and the prosecutor ended up, even with that video, ended up dismissing the aggravated assault charge and the evading arrest charge on that he really, didn't know what he was doing because he had been intoxicated against his will or against his knowledge.
Great work on that case. We have another phone call.
Well, in Harris County, it seems like it's almost gone as far as it can. Getting a blood test in every case where a person doesn't just voluntarily give the police evidence of how much alcohol is in their system. As Tyler was talking about, there's talk about a technology of like a passive alcohol detection system built into cars that's like built into the steering wheel, where just by you sitting there breathing and talking, if it detected a certain amount of alcohol, the car wouldn't start. That's really more of DWI prevention, but that's kind of the next thing that people are talking about that inevitably, the legislature is going to be requiring possibly on cars like they did seat belts, airbags, the third brake light, things like that.
Well,